Hello folks, well welcome once again to Smarter Money Matters with me, the Wealth Doctor Jeff Camarda, aided by my smarter brother Jonathan Camarda, our Chief Investment Officer at Camarda, and Super CFP Anna Wunderlich. Thanks so much for watching. Today's topic is common estate protection errors and how to fix them. In this video we'll cover the most common asset protection mistakes and how to fix them, whether you're protecting your wealth, businesses, planning for retirement, or a real estate or business owner worried about lawsuits. These asset protection strategies can really help and be solid gold for you. So protecting your wealth requires more than just good investing. It requires smart asset protection strategies. Too often successful families and business owners make these common financial mistakes that leave their nest eggs and the rest of their wealth exposed to lawsuits, creditors, divorce risk, and on all kinds of things. So we'll be talking about some really common asset protection errors to avoid, and again, how you can fix them. The first thing, I guess, is wealth protection really requires more than just investing, right? People think that wealth planning, I'm investing with my advisor, I'm investing in real estate and so forth, but it's really a big puzzle and all the pieces that need to be fit together. Common mistakes can expose families and business owners to lawsuits and creditor attack and unwanted publicity. So let's talk about some of the common errors. Would you like to begin? I know that one of your pet peeves is using the spouse as the plan. And tell me why you don't like that.
Yeah, so sometimes if one of the spouses, right, is a doctor, maybe a lawyer, some sort of industry where they're open to lawsuits, they'll want to title everything in their other spouse's name, and there can be a lot of risks to that. If that spouse got sued, then those assets are exposed. Also, if there's a divorce or some other situation, that spouse could potentially claim those assets all as their own. So there's definitely some risks there. I don't know if you have any other feedback about
No,
that.
I think that's the big one is, and I've seen that a lot in my practice over the years, particularly with doctors, and a doctor says, well, say she is afraid of being sued, so I put everything in my husband's name. Well, what if the husband gets sued? Or what if she's driving his car? There's a lot of paths to that wealth. So it has the veneer of protection, but it really is a fallacy. And so what are some of the more effective ways to protect wealth in a situation like that? Are they using the spousal option? Jonathan, you have any thoughts on that?
Yeah, well, certainly depending on the type of accounts, I think one of the more underutilized asset protection strategy and some of the common mistakes you see is not using a qualified plan effectively, which are great asset protection tools. And then also, Jeff, if they do have an LLC, making a mistake, especially in Florida, of making it a sole member versus a dual member. Because while property casualty insurance is effective and a great tool of risk management, there are some caveats and some gaps there that should be shored up though with other instruments. Yeah. So, for example, if you had a brokerage account with you and your wife within a trust and a dual member LLC, would be a great way on top of your your liability.
Yeah, so we'll get into some of the nuances of using LLCs as asset protection tools. But again, so you want to really, again, the big picture, fitting the puzzle piece together, using trusts and LLCs and legal tools, to make things as seamless and as bulletproof as possible. And when you mention qualified plans, of course, you mean things like IRAs, which technically are not qualified plans, but close enough, and 401ks and profit sharing defined benefit plans. Qualified retirement plans, by their nature in most states, are immune from creditor attack. Now, the limits vary by state, I think, and you'd have to check state law, but it's a pretty potent way to protect assets to the extent you're able to shovel money in there. But just remember, once it comes out, because you want to spend it or have to take an RMD, then it's on the table. So what are some of the other, common errors that we see that may be inadequate divorce protection, Anna?
Yeah, I mean, commingling of non-marital assets, right? So if, a couple is married and one of them inherits, assets from a family member, you want to have those properly titled to be separate from marital assets in case of a divorce. That's something that I've encountered a couple times in my practice. And again, simple, working with professionals to make sure that your things are set up the way they should can protect assets in those types of situations.
Yeah, and a good example is, say Brother Jonathan inherits $2 million from our dad. He didn't, and neither did I. But just say, it'd be nice it's a nice notion for a moment, right? So that is Jonathan's property. Now, the typical rule in most states about divorce is that assets that are accumulated during the marriage are marital property, and you have to look at other states like California that don't have common law provisions. But for the most part, assets that are accumulated during the marriage are marital property. Absent a prenup or other planning. But stuff that is you had before the marriage, or things that come to you apart from the marital partnership, like the inheritance that Johnny wish he got for $1 million, that stays Jonathan's money. Unless he does what? What's a good way for him to thwart that asset protection and divorce protection?
I mean, protective trusts, right?
Say that I'm Jonathan's husband, just
Sure.
for the moment. As enticing as that is, right? I said, Jonathan, if you love me, why won't you put that in why can't we put that in joint names? If you love me, we have everything together.
Like a house hunters episode.
Or maybe just it's something that is natural to do that because everything else is joint. As soon as that happens, now husband Jeffrey owns half of it, and it becomes marital property. And that really is typically not a wise idea, so you want to maintain that segregation. I think that's where you're going, right, Anna?
Yes.
So the risks or assets can be lost in divorce settlements. And a solution is protective trusts and structured pre- and post-nuptial planning. Getting back to something that you meant earlier about insurance gaps, Jonathan, with property casualty insurance and liability insurance, right? And that's if somebody sues you and is a claim against you, the liability insurance would cover you. And again, that doesn't always happen, right? Sometimes the insurance company, they're going to try to avoid paying that claim, and if they're successful, you're left holding the bag. Or the claim could be for more than the amount of insurance. So what are some of the risks? I see that we have here in the outline improper titling of boats, cars, and real estate. What's an application of what that pitfall could be? Anybody like to opine?
Yeah, so, if there's a spouse who primarily drives one vehicle and the other spouse's name is on that vehicle, and they're in an accident, right, that other spouse whose name is on the title could be liable in a lawsuit if they hit a NFL player or somebody else that's very wealthy and wants to go after their assets.
Yeah, and actually I had a case this past week where the couple, and I think they probably had maybe $5 or $6 million, and about $3 million of it was non-qualified, not in a retirement plan or otherwise protected. And the daughter is driving, who's got a horrible driving record, and it's a big risk actually, is driving a car that's titled in the mother's name. So tell me about that disaster waiting to happen, Jonathan. What could happen there?
Yeah, so in a situation like that, then the mom will be on the hook for whatever nefarious acts on the road that happened with her, very carefully driving daughter there. And that's a big problem as well, as you talk to a lot of people on a daily basis, that they'll have, as you mentioned, even if they don't have a terrible driving record, they will have children or maybe even family members that are either titled. You'll see a joint title, right, of a parent and their child on a brokerage account, which definitely opens up the door beyond just the typical, like you said, property casualty titling, which should be delineated to help to mitigate the unnecessary.
Yeah, so just to pull things back into focus there, so that if the daughter got in a wreck driving her mother's car, that's her mother's responsibility. The $3 million that's in a non-qualified account is on the table to satisfy the judgment, right? Or as you point out, if there's a brokerage account that's titled with the child, and which is very common, I'll put my daughter on, I die, it goes to her, we do a joint town survivorship, but then if the daughter is sued, right, because that's her account, that entire account is exposed. So much better, to use asset protection structures like the LLCs that you suggested earlier. And let's talk a little bit about LLCs maybe. Because LLCs, as probably most people don't know, these are state entities. They're created at the state level. Taxation is different. It's IRS, you check a form, tell them how you want to tax, but it's like setting up a corporation. In fact, it is a kind of corporation, and it has to follow the form and the rules of whatever state the incorporation happens in. So in Florida, the rules are different than Maryland or Texas or Oklahoma or whatever. So we have to do a couple of things that are really, really important. The first is that you want to use an LLC in a state that has strong asset protection laws, right? Florida has one, so long as you follow the form. So does Texas. Who can think of a state that maybe doesn't have a good asset protection law?
I think maybe California.
California, yeah.
Most of the Northeast, Illinois, we probably
Yeah,
not to pick on that area.
It's worth checking, but California for sure has, a lot of relatively weak protections, to protect, affluent or successful people in many cases. So you want to make sure you have a state with a strong law. And as you mentioned earlier, Florida, not Texas, but Florida requires, in order for an LLC to work as an asset protection structure, it has to have more than one owner. And owners in LLCs are referred to as members, not shareholders, but members. Weird name, right? But that's what it is. So it's got to be a multi-member LLC. And the reason for that is the basis of the asset protection stretches back to partnership law, and you can't have a partnership just with one person. But Texas doesn't. Texas, a single member LLC would work. So it's really important to make sure that the LLC is in a strong state and that the LLC follows the operating agreement, which is the primary governing document of the LLC. The operating agreement is written by an attorney that knows what they're doing to activate the asset protection opportunities. And I can tell you this often isn't done. Any idiot, even me, could set up an LLC. I've been in law school, but I'm not a practicing attorney. Can set up an LLC. It's simple, it paid a state, there's a form, but it had the nuance so it actually functions properly. You want somebody who knows what they're doing and is prepared to go into the court and explain to the judge why, I'm sorry, judge, but I know you issued a charging order for that judgment, but this entity is charging order protected, which is the term, let me tell you why. All right, so you talked a little bit earlier about underusing qualified retirement plans, Jonathan, as asset protection vehicles. Please expand a bit on that.
Well, yeah, especially 401ks, which and many, obviously it could delineate based upon the company, but are even stronger than IRAs for legal protection in some cases. And so sometimes you will see. This is why you want to work with a fiduciary, Jeff, is because some folks will encourage people to automatically roll something over, but someone who has a high probability of being sued, it may be the best advice as a fiduciary, that we use that word a lot around here, to keep that money in a 401k, because it might, many times, not all the time, you have to check, but would have even an increased level of legal protection, especially at a high probability someone could get sued. So stuff like that. IRAs as well, up to a certain amount, Jeff said it vacillates based upon the state, but 401ks in some cases could be even stronger. So that's where, again, it ties into what kind of advisor you're working with, not only their knowledge, but their incentives, where advisors like us, we can manage money at the 401ks, et cetera. So we're always in a position to really just look at what's best. So therefore, we'd still suggest you leave it there. But that's another thing you want to look at, especially high probability lawsuits. Again, where your monies are located, where your dollars are located, and who's advising you and why they're asking you or maybe instructing you to move things.
That really is a good point. And again, it's to false to state law. The protections for IRAs and 401ks are different, as you wisely point out. But it really depends on what state you're in. And that's one of many factors that you might want to consider to see if it's really in your best interest to move from a 401k to an IRA or something like that. But another thing is that if you're a business owner or if you're an employee and you have the opportunity to defer more money into your qualified plan like a 401k, if you're underutilizing your contribution opportunities, you might want to shovel more money in there. And if you don't need the tax deduction, use a Roth feature. Most 401ks now have Roth accounts. You don't get the tax deduction, but it grows tax-free, which is really kind of a wonderful opportunity. So again, using qualified plans like 401ks as an asset protection vehicle, you kind of have you kind of have your choice of tax treatment. if your 401k has a Roth feature, and most of them do these days. So if you have spare cash and you haven't hit the contribution limits, shovel more into whatever your tax advisor says is the best place to do it, and you will get asset protection on that money. You can't get everything in there, obviously, but it's one of many tools that you have. Another thing really to look at is, especially for business owners, and this is really a pet peeve of mine, if you own a business, in many cases, your most valuable asset is your business. And a good way to kind of get a beat on this is if you could sell the business without you working in it. If there's cash flow, that doesn't require your personal involvement. Some businesses are just a job, and if you stop working in it, there's no value. Others are worth millions and millions of dollars that you could sell. That you know that better than us. But if you have a valuable business, there are two ways you can be attacked. You know about the first one. Your business can be sued because of some liability. One of your employees went crazy and hurt somebody, or a crane fell on somebody, whatever. I call it a bottom-up attack. But a top-down attack, and I bet you haven't thought much about this, is if somebody sues you and that business is in your name, or you and your husband's name, and you get a judgment against you, that business is on the table to satisfy the judgment, just like your other assets. A top-down attack, and there are ways you can protect against that. Back to LLCs in Florida, having a properly structured LLC that's charging order protected, which basically means that if the judge issues a judgment, they can't get at charging order protected assets. And these can be your business, or your non-qualified investment accounts, or your bank accounts, or your investment real estate, and a bunch of other stuff. So that really, really is something that business owners, please pay attention to that. And probably the last thing, really, that you don't want to do with asset protection planning is waiting until you're sued. When that happens, your options diminish significantly. In Florida, if you try to move assets after a threat appears, it's called a fraudulent conveyance, and there's a good chance that the judge will insist that plenty be undone so you can pay what he thinks you owe. So you want to do this before the clouds appear on the horizon. Really, really important to consider that. Do you have any other concluding thoughts, Jonathan or Anna, before we wrap up this scintillatingly exciting topic on asset protection?
Yeah, well, I would just say that we see it every day in practice that these are generally very glossed over. And so if you're not really dealing with an expert, dealing in the granularity of these topics, it definitely behooves you to talk to someone who is well versed in these areas. And so, like here, we are pretty well heeled credential-wise in those areas. And a lot of clients find value. And regardless of their net worth, it's amazing how many times a lot of these proverbial pinball flippers are a little slow as far as their planning goes. So definitely take the time to make sure everything is set. You worked hard to earn it. You worked hard to earn it, and you don't want it to be taken away.
And not to over promote us, we think we're really, really good at this stuff, and we're not aware of many other firms in the country. But you want to certainly use somebody that knows what they're doing. And you might ask, if it's a lawyer, CPA, what do you think about charging order protection? What's that? Make believe you don't know much about it, and see if they can, give you the information we just have in the podcast. If not, you might want to consider somebody else. I think that we'll try to get Megan to put a link or some kind of a response mechanism into the podcast so you can get the transcript of this and the long blog post that I wrote on it, and actually some information from my last book. And some other planning points that could help you with your asset protection. You have the final word for Anna. Anything else?
I'll just add, working with clients over the years, a lot of them probably would have told me if I would have asked, is asset protection a concern for you? They would have said no at the time, and then months or maybe years later, it does come up, whether it's a lawsuit, whether it's a divorce or something like that they weren't expecting. Let's take the time now to work with your experts, such as ourselves, and make sure that the way that your wealth is set up is the best, most protected way it can now, before these threats materialize later.
Yeah, and the odds of that happening pretty remote. But if your number comes up, you're probably going to be screwed. I mean, there's a lot that's on the table. So that's a really good point. So let's finish with that. Very frequently, advisors, in my experience, are very rare that even get into issues like this, asset protection planning. But if it's clearly laid out, as we go through our Wealth 360 process, which is something we do free for everybody, kind of as an example of our work, and I'd say, okay, Megan, I see that you've got an account at the bank with your husband that's worth about $800,000. If somebody sued you, they could take that away. It's exposed. Do you care about that? Would you like to look at some strategies to maybe protect it and keep it, from being lost to a lawsuit? Everybody always says, heck yeah, but that question is not asked nearly enough. So ask yourself that, and if you're in that category, please, if you don't get help from us, get help somewhere. Thank you so much for watching. And that will wrap up this week's edition of Smarter Money Matters with the Wealth Doctor, Jeff Camarda, my smarter brother, Jonathan Camarda, CFA, and other letters ad nauseam, and Super CFP at a Wonderland. Thanks so much for watching. See you next week.